which are all domestic violence offenses. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire an attorney of your choice, and in certain circumstances, an attorney may be appointed on your behalf. We are going to discuss your conditions of release today. I have reviewed the probable cause statements provided by the arresting agency, and I have reviewed information provided by pretrial services. It's my understanding that one of the alleged victims is also present on the line, and I would allow her to speak before I determine your conditions of release. And I'm so sorry, I don't know, this is the case where the victim requires the interpreter. I don't know if you want to tell her everything I just said or just invite her to let me know what she would like me to know.
I will introduce myself and allow her to speak, Your Honor. Sí, muy buenos días. Le dice la juez a la persona que se encuentra en la línea, víctima del señor Oscar Barrios, que si desea decir algo.
Sí, nada más quería saber si, bueno, si va a salir hoy, si él va a venir a la casa, está bien, pero me gustaría que le pusieran algún tratamiento para el alcohol, alguna rehabilitación, por favor.
Okay.
Porque, o sea, él puede venir a la
Ajá.
casa.
Okay.
Él puede venir a su casa.
Okay. Yes, the only thing that I would like to know if he is being released today. If that is the case, it's okay for him to come home. It's okay. I would only request from the court, if it's possible, that he receives rehabilitation, some kind of treatment for his alcoholism, please. Because, I mean, he can come home, but he does need help, some type of rehab. And that's all. Thank you.
Ma'am, to the best of your knowledge, has he ever been involved with a substance abuse treatment program?
Señora, le dice la juez, ¿usted sabe si el señor ha participado en algún tipo de programa para rehabilitación de sustancias tóxicas?
Pues no, lo que yo, pues es que él tuvo un accidente, él se cayó de un tercer piso, entonces cuando lo sacaron del hospital fue a un como behavioral center del Banner y estuvo ahí como 3 días, 4, no, más o menos esos días.
Okay. No, I really wouldn't know. The only thing I can say is that he had an accident and he fell from the 3rd floor all the way down. And once he was released from the hospital, he went to the behavioral center in Banner, and he was there for about 3 or 4 days, more or less. That's all I know.
Thank you.
Okay, gracias, señora.
De nada.
You're welcome.
All right. Mr. Barrios, if I were to order that you were released on your promise to appear, would you appear at your future court date?
Yes.
All right. So I will order that you are released on your promise to appear for future court dates. The additional orders are that you may not possess or consume alcohol or illegal drugs. You may not commit any acts of domestic violence, and I'm going to order that you obtain a substance abuse evaluation. Your next court date is scheduled for August 1st at 10:30 in the morning. That's at Pima County Justice Court with Judge Pesquiera. Do you understand?
Yes.
And Your Honor, may the interpreter interpret that for the victim?
Yes.
Bueno, dice la juez que va a ordenar que el señor salga de la cárcel con la promesa de honor que va a presentarse a su audiencia futura. y como parte de las condiciones de liberación le está ordenando la juez que no puede consumir ningún tipo de sustancia tóxica, ni drogas ilegales, ni tampoco alcohol. Y tampoco puede cometer actos adicionales de violencia doméstica. Y la juez también va a ordenar que al señor se le haga una evaluación para las sustancias tóxicas o para el abuso de sustancias tóxicas. Y la próxima audiencia a la cual se tiene que presentar es el 1 de agosto a las 10:30 de la mañana en Pima County Justice Court ante el juez Pesqueira.
And Mr. Barrios,
Okay, está bien.
All right, that's okay.
thank you. If you do fail to appear for future court dates, a warrant can issue for your arrest.
Okay.
All right, that's all for today.
Thank you.
Y dice la juez, señora, que si el señor no se presenta a esa audiencia, se puede emitir otra orden de arresto para que lo detengan. Y es todo por hoy. Gracias.
Oh, right.
Una pregunta nada más. ¿Tenemos que ir por él o?
And Your Honor, the victim has a question. She's asking if she or they go and pick him up at the jail.
I think that you can do that, and it usually takes, 2 to 4 hours for release to be processed?
4 to 6, Your Honor.
4 to 6 hours.
Okay. May I say that to the victim?
Yes, please.
Okay. Señora, dice la juez que normalmente, que usted puede hacer eso, ir por él, pero normalmente el proceso toma de 4 a 6 horas. Entonces, desde hoy, de 4 a 6 horas más, puede que ya salga.
O que nada más hablo a la cárcel y pregunto a qué hora va a salir, ¿verdad?
So if it's better to call the jail and just ask at what time he's going to be released?
I think that might.
So, Your Honor, if somebody calls the jail and asks if a person's been released, they're not going to give that information. What her son would have to do is call them when he is released. And there's a phone outside. He's able to do that, but he'd have to get in touch with them. They can't call the jail and get the information from the jail.
Okay.
May I say that, Your Honor?
Yes, please do.
Bueno, señora, le dice el señor, el fiscal encargado de la cárcel, dice que si usted llama a la cárcel no le van a dar información. Lo ideal es que su hijo, cuando él salga de la cárcel, hay un teléfono que va a poder usar y él les puede llamar a ustedes. Pero si usted llama a la cárcel, no le van a dar información.
Está bien, okay.
All right,
Muchas
thank
gracias.
you. Thank you very much.
Bye.
Ya puede colgar, señora, gracias.
Okay, gracias.
Thank you.
And the victim is disconnecting, Your Honor.
Thank you. I believe that there are no further Spanish speakers, and so the interpreter may be excused. Thank you so much for your assistance.
You're welcome, Your Honor. Have a good day.
Please state your name, sir.
Yes, ma'am.
That's for you.
What's your name?
Oh, Monty Johnson. I'm sorry, I'm hard of hearing.
That's okay.
I got no hear. I don't hear anything.
Mr. Johnson, this is the time for your initial appearance. You are here this morning on charges of failing to comply with a court order, which is a domestic violence offense. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire an attorney of your choice, and in certain circumstances, an attorney may be appointed on your behalf. We're going to discuss your conditions of release this morning. I have reviewed the statements from the arresting agency, and I have reviewed information about you from pretrial services. Sir, if I ordered that you were released on your promise to appear for future court dates, would you appear at your future court date?
Yes, ma'am.
Thank you. If I further ordered that you could not have any contact with your ex-girlfriend, Amber Nix, would you abide by that condition?
Yes. All my personal belongings are at that house. I mean, I lived there for 3 years. What do I need to, how do I go about it? I wasn't trying to violate this time. No, I didn't know.
She'll explain.
Oh, okay.
So I will order that you may return one time to the home with a police escort to obtain your belongings. You'll take my
Thank you.
order. So you'll take my order to the closest police station to the residence, and they will escort you there to obtain your belongings. Okay? Right.
Thank you, ma'am.
So I'm ordering that you are released on your promise to appear. The additional conditions of your release are no alcohol or illegal drugs, no acts of domestic violence, no contact with the alleged victim, do not return to the incident location except for that one time with a police escort. Your next court date is August 1st at 1:30 for a domestic violence arraignment at Pima County Justice Court. If you fail to appear, a warrant can issue for your arrest. Do you understand?
Yes, ma'am.
All right, thank you. That's all for today.
And Judge, that was 1:30?
Yes.
Okay.
No, sorry, 10:30.
10:30. Okay.
So it's August 1st at 10:30.
Understood.
For me.
Yeah, that's for you.
Thank you, ma'am.
Richard?
Good morning. Please state your name.
Richard Pleasure.
Great, Mr. Cluggett, this is the time for your initial appearance on charges of assault, which is a domestic violence offense. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire an attorney of your choice, and in some circumstances, an attorney may be appointed on your behalf. We are going to discuss your conditions of release today. If I were to order that you were released on your promise to appear for future court dates, would you appear for your future court dates?
Yes.
Thank you. And if I were to further order that you could not have any contact with the alleged victim, Jennifer Santos, you cannot go to her residence or workplace, would you abide by those conditions?
She's currently living in my house that I own.
Okay. So at least temporarily, if that's where she's residing, I'm ordering that you cannot be there. So I would allow you to return one time with a police escort to pick up your necessary belongings. And then those are things that could be worked out later. And those orders could be changed later. But until further order of the court, you would only be allowed to go there one time with a police escort. Is that something you can abide by?
Yes, Your Honor.
All right, so I will order that you're released on your promise to appear. The further orders are no alcohol or illegal drugs, no acts of domestic violence, no contact with the alleged victim, and do not go to the incident location, except for that one time with a police escort. Your next court date is August 1st at 10:30 in the morning with Judge Pesquiera at Pima County Justice Court. If you fail to appear, a warrant can issue for your arrest. Do you understand?
Yes, Your Honor.
Thank you. That's all for today.
Yeah, I keep them in my house. Like I own my.
What you have to do is
Good morning. Please state your name.
Warren Thomas Lyles II.
Mr. Lyles, this is the time for your initial appearance on a couple of different matters. You have a new charge of possession of drug paraphernalia out of Marana City Court, and then you also have a charge from September of 2023 of driving under the influence out of Pima County Justice Court, for which a warrant had been issued for your arrest. You have the right to remain silent on both of these matters. Anything you say can and will be used against you. You have the right to hire an attorney of your choice, and in certain circumstances, an attorney may be appointed to represent you. We are going to talk about your conditions of release this morning. I am going to order that you are held on a bond of $50 in the drug paraphernalia case and $200 in the driving under the influence case. You will be seen by the respective courts tomorrow. Let's see. And I think that that is only possible if you remain in custody. So one of the hearings would be tomorrow at noon, and the other one would be tomorrow at 1 p.m. Do you believe that you would be able to post bond before then, or do you believe that you would remain in custody until you see the judge tomorrow?
I'm honestly, I'm not sure.
Okay. All right, I don't want to extend the time before you could see a judge if you stay in. So what I'm going to do is I'm going to do 250 on the DUI and release you on the Miranda case instead. So you'll be seen tomorrow, whether you are in custody or not, on the Pima County Justice Court driving under the influence charge at 1 p.m. If you are still in custody, the jail would make you available. If you are not, then it would be your responsibility to appear. And if you failed to appear, a warrant would likely issue for your arrest. The additional orders are no alcohol or illegal drugs, do not drive without a valid driver's license, and I am appointing Janet Altschuler to represent you. And then in the Miranda case, I will order that you are released on your promise to appear. And your next court date will be August 27th at 10 a.m. in that case. And if you fail to appear for that hearing, a warrant could issue for your arrest. Do you understand?
Yes.
I am appointing Janet Altschuler to represent you in the driving under the influence case. And that's all for today.
Steps. Parnell. Parnell. Yeah.
Good morning, please state your name.
Brian Parnell.
Mr. Parnell, you are here this morning on your initial appearance for a couple of different matters. You have a warrant out of Marana City Court for charges of shoplifting from October of 2024.
Yes.
And they also added a charge of failure to appear in November of 2024. And then you have charges from 2023 and 2024 out of Tucson City Court that were in warrant status for possession of drug paraphernalia, criminal trespass, and shoplifting. You have the right to remain silent on all of these matters. Anything you say can and will be used against you. You have the right to hire an attorney of your choice, and in certain circumstances, an attorney may be appointed on your behalf. We are going to discuss your conditions of release. And in the Tucson City Court matters, I am going to order that you're held on a bond of $250, cash or secured. The additional conditions of your release are no alcohol or illegal drugs, no contact with the alleged victims of the trespass or shoplifting charge, and do not return to those incident locations. And I will appoint the City of Tucson Public Defender to represent you. If you remain in custody, your next court date for those matters will be August 1st at 1:45. If you post bond and are released, they're going to vacate that court date, and your next court date instead will be just make sure, August 22nd at 9 a.m. for a pretrial conference. And if you were to fail to appear, a warrant could issue for your arrest. And then on the Marana charge, I will order that you are released on your promise to appear, and your next court date will be August 27th at 10 a.m. If you fail to appear for that hearing, a warrant can issue for your arrest. The additional conditions are no alcohol or illegal drugs, no contact with the alleged victim, and do not return to the incident location. Do you understand?
Yes.
All right, thank you. That's all for today.
Yeah, I chose. I want to do that. That's the bond. Yeah, it's right now. That yeah. And what is the bond again? $250. Just and then open cash or security. Yeah. Molina.
Please state your name.
Benjamin Molina.
Mr. Molina, this is the time for your initial appearance on charges of assault, disorderly conduct, and possession of drug paraphernalia out of Tucson City Court. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire an attorney of your choice, and in certain circumstances, an attorney may be appointed on your behalf. You are presumed to be innocent, and I will enter pleas of not guilty on your behalf today. We are going to discuss your conditions of release, and to prepare for that, I have reviewed the information provided by pretrial services as well as the officer's narrative from the arresting agency. And I am going to order that you are held on a bond of $500 cash or secured. The additional orders are to possess or consume no alcohol or illegal drugs, commit no acts of domestic violence, possess no firearms or weapons. If you do have any firearms, you must surrender them to Tucson Police Department within 48 hours of release. You may have no contact of any kind with Nancy Moreira, and you may not return to her residence or workplace. I believe that you were living in the same residence, so if you would like to return one time to obtain your necessary belongings, you may do so with a police escort. You will take my order to the closest police station, and they will escort you to the residence to obtain your necessary belongings. I will appoint the City of Tucson Public Defender to represent you. And the final order is that you must contact your pretrial services officer on the first working day following your release from custody in your Superior Court case. Your next court date, if you remain in custody, will be on July 30th at 1:30 in the afternoon. That's for a video review. And it will be the same date if you post bond and are released. Those are with Judge Million of Tucson City Court, and if you fail to appear, a warrant can issue for your arrest. The hearings can also go forward without you, including trial, and if you are convicted and fail to appear for sentencing for 90 days, you can lose your right to a direct appeal. Do you understand, sir?
Yes, I do.
All right, thank you. That's all for today.
Thank you. Yes, Felix.
Good morning. Please state your name.
Good morning, Rebecca Natividad Ruiz Felix.
Mr. Ruiz-Felix, this is the time for your initial appearance. You are here on one charge of assault and 4 charges of disorderly conduct, which are all domestic violence offenses. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented. You have the right to hire an attorney of your choice, and in certain circumstances, an attorney may be appointed on your behalf. And we are going to discuss your conditions of release. I have read the officer's narrative and I have read information provided by pretrial services about you. If I were to order that you were released on your promise to appear for future court dates, would you appear for your future court dates?
I promise, Your Honor.
Thank you. And if I were to order that you could not have any contact with Rodolfo Felix, would you be able to abide by that condition?
I can, yes.
All right. And so pretrial services was not able to speak with him. All of the other victims indicated that they were still willing to have contact with you. But I do want to make it clear that it would take an order of the court to allow you to have contact with Mr. Felix, not just him saying it's okay.
I understand.
All right. So I will order that you're released on your promise to appear. The additional conditions of your release are to possess or consume no alcohol or illegal drugs, commit no acts of domestic violence, no contact with Mr. Felix, don't go to his home or workplace. And then your next court date will be on August 25th at 9 a.m. for a pretrial conference. If you were to fail to appear for that hearing, a warrant could issue for your arrest. The hearings could go forward without you, including trial. And if you were convicted and then failed to appear for sentencing, you could lose your right to a direct appeal. Do you understand?
I understand, Your Honor.
A couple things, Your Honor. Was that at Justice Court?
Tucson City Court.
City Court, okay. And
Do you?
My mother.
okay.
Yeah.
So one of the alleged victims is her mother, with whom she resides. So are there orders the court can in place?
There are no restrictions on contact with her mother.
Okay. Okay.
And then I will enter pleas of not guilty for you. Today, you are presumed to be innocent. Any other questions?
No, Your Honor.
Okay, thank you. That's all for today.
Thank you.
Please state your name.
Christina Valverde.
Ms. Valverde, this is the time for your initial appearance. You are here this morning on charges of disorderly conduct, which is a domestic violence offense, as well as obstructing a highway. Appears to be it's a previous hearing out of Tucson City Court. You have the right to remain silent in both of these matters. Anything you say can and will be used against you. You have the right to hire an attorney of your choice, and in certain circumstances, an attorney may be appointed on your behalf. We are going to discuss your conditions of release, and I have been provided with the officer's narrative as well as information from pretrial services. If I were to order that you were released on your promise to appear, would you appear for your future court date?
I promise, 100%.
And if I were to order that you couldn't have any contact with Brandon Neville until further order of the court, you can't go to his residence or workplace, would you be able to abide by that condition?
Yes.
So I will order that you are released on your promise to appear. The additional conditions of your release are not to possess or consume alcohol or illegal drugs, and not to commit any acts of domestic violence, no contact with Mr. Neville, you can't go to his residence or workplace. Do you have belongings at his residence that you need to obtain?
Yes.
So I will order you can return one time with a police escort to obtain your belongings. You'll take my order to the closest police station and they will escort you there to obtain your belongings. And then your next court date is going to be on August 26th. That's at 1:30 in the afternoon before Judge Millian at Tucson City Court. If you failed to appear for that hearing, a warrant could issue for your arrest. The hearings could go forward without you, including trial. And if you were convicted and failed to appear for sentencing for 90 days, you could lose your right to a direct appeal. Do you understand?
I do.
Was that August 1st, Your Honor?
August 26th.
26. Oh. Thank you, Judge.
You're welcome. And I will enter a plea of not guilty. You are presumed to be innocent, and that's all for today.
Okay, thank you.
Mr. Warriors.
Please state your name.
Dominic Warrior.
Mr. Warrior, this is the time for your initial appearance on misdemeanor charges of disorderly conduct that is a domestic violence offense. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire an attorney of your choice, and in certain circumstances, an attorney may be appointed on your behalf.
Sorry, what were the charges again? I'm so sorry.
Disorderly conduct, domestic violence.
They told me it was trespassing. I'm so sorry. Yeah, I don't want to. Okay. If you say it's fine, it's really not though. Because that's not what I got charged with. That is what you're being charged with. I got charged with trespassing. It says on the paper when I got here. I promise you that.
Give me just a moment. We're having a technical issue over here, and I'll be right back with you.
Yeah, I got charged with trespassing when I got charged, but okay.
Thank you.
I'm not gonna take a charge that is gonna fuck up the record. You know what I mean?
All right, thank you. Okay. So the charges that have been brought before me are disorderly conduct, a domestic violence offense. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire an attorney of your choice, and under certain circumstances, an attorney may be appointed on your behalf. We are going to discuss your conditions of release. I have reviewed the officer's narrative, and I have also reviewed information provided by pretrial services. Sir, if I were to order that you are released on your promise to appear for your future court dates, would you appear?
Sure.
All right.
But
If I were, sir,
I'm so sorry to cut you, but why was I charged with trespassing? But that does not make sense. I'm not gonna be charged with disorderly conduct if I got charged with trespassing.
I've seen the trespassing paperwork, and
It's up in the front.
I
Like
can't answer your question, sir.
that's
What
what
I
the
can tell
officer
you
told me.
is that
But I
what
just
I
don't want to
have,
be. I know. I just don't want to be taking a charge that I got charged with trespassing. They never told me disorderly conduct. They never said anything about the second one either.
okay. So
In the nicest way possible.
what I'm going to tell you, Mr. Warrior, is that the charges that come to court do not have to be the charges you were arrested on. They can dismiss those old charges and go forward on different charges. Okay, so
Good.
if I were to order that you could not have any contact with Seferino de la Rosa and Mr. de la Rosa, would you abide by that condition?
Yeah.
All right, so I will order that you're released on your promise to appear for future court dates. The additional orders are no alcohol or illegal drugs, no acts of domestic violence, no contact with Mr. and Mrs. De La Rosa, don't go to the victim's residence or workplace. Your next court date will be August 25th at 9:30 in the morning with Judge Mayhew at Tucson City Court. If you fail to appear for that court date, a warrant can issue for your arrest. The hearings can go forward without you, including trial. And if you are convicted and then fail to appear for sentencing for 90 days, you can lose your right to a direct appeal. Do you understand?
Yes, ma'am. So you're saying I didn't get charged with trespassing at all? It just is disorderly conduct.
So I don't have all of the world of information in front of me, but I do not have any criminal trespass charges in front of me. I can tell you that. I will enter a plea of not guilty on the disorderly conduct charge, and you are presumed to be innocent. And that's all for today.
Okay, thank you. Okay, thank you, sir.
Good morning. Please state your name.
Marcus Lester.
Mr. Lester, this is the time for your initial appearance on charges of shoplifting. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented. You have the right to hire an attorney of your choice, and in certain circumstances, an attorney may be appointed on your behalf. We are going to discuss your conditions of release. Sir, if I ordered that you were released on your promise to appear for your future court dates, would you appear for your future court dates?
Yes.
All right, so I will order that you are released on your promise to appear.
Your Honor, can I tell you something though? I just want to tell you something that this hold on. I know I've been doing this a long time. I just want to tell you, ma'am, that this right here was a result. Yesterday I called 911 7 times. I was trying to get to the hospital for some mental health reasons. No one would help me. I'm SMI. I've been SMI since I was 12 years old. I've been sent to prison 4 times as a result of doing things from my mental illness. And every time I try to get help, there's never no help, ma'am. So this was a result of me just trying to get somewhere safe so that I would be safe and the community, ma'am. I just want you to know that.
So, sir, I could order that the folks at the jail do a mental health evaluation and determine whether they believe anything needs to be filed regarding treatment for you before you're released. Would you like me to do that?
No, I mean, I feel fine now, but yesterday I was in a crisis.
Okay. All right. So I will order that you're released. I will order that you may not have any contact with Circle K. You cannot return to the Circle K. All right?
Okay.
Your next court date is going to be August 22nd at 9 a.m. That will be with Judge Hale at Tucson City Court. And if you fail to appear for that court date, a warrant can issue for your arrest. Do you understand?
Yes, ma'am.
The hearings can also go forward without you, including trial. And if you were convicted and then didn't show up for your sentencing hearing for 90 days, you could lose your right to appeal your conviction. Do you understand that?
Yes, ma'am.
Great. I will enter a plea of not guilty for you at this time, and you are presumed to be innocent. Oh, sorry, that's the wrong direction. And that's all for today. I hope that if you are feeling bad on another day, you are able to get the assistance you need without being arrested.
Okay. Thank you.
Thank you. Please state your name.
Robert Casey.
Mr. Giese, this is the time for your initial appearance. You are here on a third-degree felon or a class 3 felony of luring, and you do have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney, and it is ordered appointing the Pima County Public Defender's Office to represent you. We are going to discuss your conditions of release this morning. I have reviewed the interim complaint describing the circumstances surrounding your arrest. I have also reviewed information provided by pretrial services about you. Actually, I was only able to see minimal information before, so I'm looking to see what's available now. All right. And then I have reviewed the state's recommendation. The state is recommending that you are held on a bond of $150,000. Would the state like to be heard further?
Yes, Your Honor. This person has demonstrated that they are an absolute and present risk to a very vulnerable demographic. And unlike most of the defendants we see with charges like this, there's not a computer between them and the potential victim. This person allegedly approached the victims more than once. This person did so with a vehicle which would aid him in absconding with the potential victims. Your Honor, this person, there is no condition of pretrial release that could possibly ensure the safety of the community, given what the defendant has demonstrated himself to be a risk of. Furthermore, there is a very high risk of prison time in this situation, that flight becomes a very real and concerning risk. Given everything we have here, Your Honor, this individual could take the vehicle that he was in and disappear, and we would never see him again. And he would pose this risk to other members of the community of his preferred demographic. $150,000, Your Honor.
Thank you. And defense.
Yes, Your Honor. So I want to start off by noting, of course, for the court's record and for the folks at home, that this is just merely an allegation. The state has not proven anything. They've issued an interim complaint with some information, and that is what we have to work with here today. The state's asking that Mr. Giese be held because of, some danger that they claim, that they allege that there's an enormous flight risk that is not, of course, demonstrated by anything that is alleged in the complaint, nor anything that pretrial services compiled on Mr. Giese's behalf. So the long and short of it is, a bond in this case, I think, is inappropriate. I think pretrial services release is more appropriate under the circumstances. And the circumstances are such that Mr. Giese's got a home to go to. He's got third-party custody, someone who can make sure that he, abides by the conditions imposed by the court. I think that if the court were to impose an order, no contact with any minors, I think that that would be sufficient to ensure his compliance with that order. He's got a place to go, a person to stay with, no minors in the home. He has no prior history to speak of, no felony history, no misdemeanor history that's been reported. This is not somebody who presents a substantial risk of failing to appear, not somebody who presents a risk necessarily to the community or to the specific alleged victims in this case. So those are the things that the court needs to take under consideration, in addition to Mr. Giese's financial circumstances, his own ability to post the bond. The court must take his own ability to post into consideration. If the idea is to hold him on, some enormous exorbitant bond that he has absolutely no hope or no chance of paying, then what the court is essentially doing is punishing him before the state has, had a trial or attempted to prove him guilty beyond a reasonable doubt. Pretrial detention is not pretrial punishment. It is to hold somebody because they present a substantial risk to the community, listed victims, or a risk of flight. And we just don't have that here, Your Honor. There are some issues with the complaint. The first being the date on the first page filled out says July 7th, 2025. That's different than other dates listed elsewhere in the complaint. There's factual issues as it relates to identification of the vehicle and the suspect by the witnesses, the alleged victims in this case. There's two groups, of alleged incidents essentially, and they, either group of minors described a different vehicle. The person that they described is someone 30s to 40s in age, and within an hour of the first incident is the second one, again listing a different vehicle, a different color, and more to the point, Your Honor, the statements that the suspect allegedly made, I don't believe there to be probable cause to believe that actually meets or matches what's described in the elements for this charge. There's got to be offering or soliciting sexual conduct with another person, and based on the statements that are listed in this complaint, as described by the alleged victims, I don't believe that those statements match what the conduct that is criminalized under this statute. So I believe there to be an issue not only with the identification, but the probable cause. There was never, a show up conducted or anything, connecting Mr. Giese to either of these situations. There's issues with the identification of the vehicles and the suspect by these people who are making the allegations. But more to the point, Your Honor, Mr. Giese, would like the opportunity to, present a defense and to do so not from within the jail, but from the home that he could share with his father, because he has the ability to have that transport to and from his court hearings, have a place to go to, and supervision both by his father and pretrial services is going to be sufficient to ensure that there aren't any issues while this case is pending.
Thank you. I have considered all of those arguments. I do find that there is probable cause for the alleged charges, and I am going to order a bond of $100,000, cash or secured. If you are released, you'll be released to pretrial services. Monitoring or treatment is directed by pretrial services. No alcohol or illegal drugs. No firearms or weapons. No contact with the alleged victims. Do not return to those incident locations, and no contact with any minors. Your next court date is on August 1st at 1:30 for a preliminary hearing. If you were to fail to appear for future court dates, a warrant could issue for your arrest. You understand?
Yes, Your Honor.
Thank you. That's all for today.
Thank you, Your Honor. Thank you.
Good morning. Please state your name.
Andrew Michael Rivera.
Mr. Rivera, this is the time for your initial appearance. You are here this morning on charges of possession of a dangerous drug, possession of a narcotic drug, and possession of drug paraphernalia. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney, and it is ordered appointing the Pima County Public Defender to represent you. I do also see that it looks like you are detained without bond currently in another matter. So regardless of what I ordered today, you would not be released until that matter was resolved. We are going to discuss your conditions of release, and I have reviewed the interim complaint. I have also reviewed information provided by pretrial services, including whether you have any prior felony convictions, and if so, what those look like, and information that you or any references were able to provide regarding your ties to the community. I have also reviewed their assessments and recommendations. Finally, the state is recommending that you be held on a bond of $5,000, and noting that they could have asked that you be held without bond on this matter because under the Arizona Constitution, you don't have a right to bond if you are alleged to commit a new felony while you are on release for a previously alleged felony. Would the state like to be heard any further?
No, Your Honor.
And defense.
Yes, Your Honor. Given the held without bond on another case, I'd ask that the court impose a nominal bond here. I'm asking for $1,000 under the circumstances. Given Mr. Rivera's financial situation, I don't know that $5,000 would be something that he would at any point in the future be in a position to be able to actually post. I will note that pretrial services indicated that he's eligible for STEPS diversion screening. I note that the county attorney's office did not recommend that. I am, however, recommending that you order Mr. Rivera be screened for STEPS. This is clearly, the allegations here are of substance abuse. I think that the programming through STEPS and that opportunity of diversion, I think, would be in Mr. Rivera's benefit. So for these reasons, Your Honor, I'm asking you screen him for STEPS, and then you impose a nominal bond just to make sure that he's getting his back time while he resolves both this case and the other.
Thank you. And does the state have any objection to me setting a steps hearing?
One moment, Your Honor. Checking one additional thing. Your Honor, this defendant has an extensive, and I mean extensive, conviction history to include drugs, violent crime. I can emphatically state that he is not steps eligible.
Um, and then, counsel, with that information, are you still asking for the steps hearing to be set?
I am reviewing the criminal history provided by pretrial services, which they of course had the benefit of reviewing when they noted that he was eligible for steps. The only violence related conviction is in looks like an aggravated robbery from over a decade ago. I know that there's most of the convictions seem to be for drug related offenses, and so I do think that steps is appropriate, and I think again a better use of the state's resources than continued incarceration or criminal prosecution. So for these reasons, Your Honor, I do think that it's appropriate. I'm asking that you order he be screened.
I will set the hearing, so that'll be on July 29th at 9 a.m. Sir, if you happen to be released before then, I believe you only get one chance to be screened for the STEPS program, so it would be very important to appear at that hearing. And then I will order the bond of $1,000, cash or secured. If you are released, you'll be released to pretrial services. You'll be required to submit to monitoring or treatment as directed by pretrial services. No alcohol or illegal drugs, no firearms or weapons. Your next court date, your preliminary hearing date will be August 1st at 1:30. It's possible that hearing may not go forward. However, it's important to be aware of your court dates because if you fail to appear, a warrant can issue for your arrest. Do you understand, Mr. Rivera?
Yes, I do.
Thank you. That's all for today.
Your Honor, just for record keeping, if this court could note for the minute entry that this is over state's objection for the referral steps.
Yeah. All right, that's all for today. Thank you.
Well,
Good morning. Please state your name.
Benjamin Williams Grove.
Thank you, Mr. Scurro. This is the time for your initial appearance. You were arrested on a warrant out of Pinal County for possession of drug paraphernalia. That is a felony offense. You have the right to remain silent. Anything you say can and will be used against you. And I have been instructed by an administrative order to honor the bond amounts set on warrants by out-of-county judges. So I will be imposing the $2,500 bond that was issued when the warrant was issued out of Pinal County. And then what I'm going to do is set a hearing in about 30 days to see if you have been released to Pinal County or if you are still being held here for some other reason. That will be on August 22nd at 9 a.m. If you are still here, the jail will make you available like they did this morning. If you have been released to Pinal County, then you will not need to worry about that hearing. We will just note that you have been released and stop having hearings on the issue. Do you understand?
Yes.
All right. So that review will be August 22nd at 9 a.m. And I've also been asked to order that if you are released, that you contact your assigned probation officer on the first working day following release from custody. And I will also order no alcohol or illegal drugs as a condition of release. Do you understand?
Yes. Yes, ma'am.
All right, that's all for today.
All right, felony, get up. Get up.
Good morning. Please state your name.
Tommy Bob.
Mr. Bope, this is the time for your initial appearance. You were here on a couple of different matters. There was a felony charge of possession of drug paraphernalia, and then you have misdemeanor charges out of Tucson City Court that were in failure to appear status from 2022 for criminal trespass. You have the right to remain silent on all of these matters. Anything you say can and will be used against you. You have the right to be represented by an attorney in the felony matter, and in the misdemeanor matter, you always have the right to hire an attorney of your choice. In certain circumstances, an attorney may be appointed on your behalf. I have been informed that the state is moving to dismiss the felony drug paraphernalia charge. So I will order that that is dismissed without prejudice. And then turning to the criminal trespass charge, it looks like you've never appeared in court on that charge. Is that correct?
That's correct.
If I were to order that you were released on your promise to appear, would you appear at your future court date?
Would.
Great. So I will order that you're released on your promise to appear. Your next court date is going to be August 22nd. That's at 9 a.m. That is at Tucson City Court with Judge Mayhew. If you fail to appear for that hearing, a warrant can issue for your arrest. And the additional conditions of your release are to possess or consume no alcohol or illegal drugs, have no contact with the alleged victim of the criminal trespass, do not return to that incident location. Do you understand?
Do.
Great, thank you. That's all for today. Please state your name. Mr. Bill, this is the time for your initial appearance. You are here this morning on charges of arson of an occupied structure, criminal damage over $10,000, and endangerment. You have the right to remain silent on all of these matters. Anything you say can and will be used against you. You have the right to be represented by an attorney, and I am appointing the Pima County Public Defender's Office to represent you. We are going to discuss your conditions of release today. I have reviewed the information contained in the interim complaint. I have also reviewed information provided by pretrial, know whether you have any felony criminal history and whether you were able to provide information or references regarding your ties to the community. It also contains their assessments and recommendations. And I have reviewed the state's recommendation that you be held on a bond of $50,000. Would the state like to be heard further?
No, Judge.
Thank you. And defense.
Yes, Your Honor. I'm actually going to be asking here that you dismiss the arson count. I don't believe that there's probable cause for the count as it's alleged. What Mr. Buell has been charged with is arson of an occupied structure, which requires that a person knowingly and unlawfully damage an occupied structure by knowingly causing a fire or explosion. The important thing there is that there has to be damage to the structure, which is the building itself. It's defined under 1701. However, what is alleged here is that there was a fire started on a desk inside the building. Clearly, what the state has alleged and what's described in the complaint is damage to the desk itself. There's nothing in the complaint that notes any damage to the building. What perhaps Mr. Buell could have been charged with was reckless burning, which is described as, recklessly causing a fire explosion, which results in damage to an occupied structure, a structure, wildland, or property. And so property would mean objects within the building itself, not necessarily the building. And so, charging Mr. Buell with the class 2 felony arson of an occupied structure, there's simply no probable cause to believe that there was any damage to the structure itself, wasn't alleged as such in the complaint. And so, therefore, there's no probable cause to believe that Mr. Buell caused any damage by means of arson to this occupied structure. So I'm asking the court to dismiss for lack of probable cause on that count, and then release Mr. Buell to pretrial services so that he can continue defending himself, working with the public defender's office as it relates to the other counts. Clearly, there's a mental health component involved here. It's described as such in the complaint. I think that this is something that is a fairly significant factor. We might be looking at Rule 11 in this case, Your Honor. And so I don't know that holding Mr. Buell in jail is the right way to, allow him to present his defense, work with the public defender's office, explore the mental health angle that seems to be such a significant portion of this case. And so for these reasons, Your Honor, I'm asking you to dismiss for lack of probable cause on the arson count, and then release Mr. Buell to the supervision of pretrial services at the enhanced level, if necessary, for the remaining counts. Thank you.
Your Honor.
Just a moment. I just wanted to first say that I don't think there is an enhanced level of pretrial services that I can order. They just determine that based on their own assessments. And go ahead, Mr. Poston.
Your Honor, the charge as it stands fits perfectly. What we have here is the defendant is alleged to have walked into the lobby of this motel, hotel, whatever it's called, and sprayed some sort of accelerant on the counter and then lit it on fire. Now, if this were a desk, if this were a table sitting in the middle of the lobby, perhaps counsel's argument would hold water. However, looking at what I see here, it was the front desk and into the clerk's area, causing upwards of $10,000 in damages. Now, it's not a movable desk. It's not a piece of furniture. It's the counter that was integral, built into the building, and he lit it on that counter and the surrounding area on fire. Anybody with a web browser can go to the news coverage of this and see this fact that the counter is built into the building, and that was the area that was lit on fire. This absolutely does constitute probable cause. Furthermore, the defendant absolutely admitted to his actions post Miranda to law enforcement, giving some what he thought was a reasonable excuse or justification. Your Honor, probable cause is here aplenty. Thank you.
Thank you. I do read that the definition of a structure under 13-701 is any building, object, vehicle, watercraft, aircraft, or place with sides and a floor used for lodging, business, transportation, recreation, or storage. And I do read that it does clearly say it was onto the front desk and into the clerk's area behind the plastic partition. So I do find probable cause, and I will order that the defendant is held on a bond of $50,000 cash secured. If you are able to post bond and be released, you'd be released to pretrial services. Monitoring or treatment is directed by pretrial services. No alcohol or illegal drugs, no firearms or weapons. If you do own any weapons, you must surrender them to local law enforcement. No contact with the alleged victim, and do not return to the incident location. Your next court date will be on August 1st for a preliminary hearing. That's at 1:30 in the afternoon at Pima County Justice Court. If you were to be released before then and then fail to appear for future court dates, a warrant could issue for your arrest. Do you understand, sir? All right, thank you. That's all for today. And I will note, I didn't hear a response, but I saw the defendant nodding in the affirmative.
Oh.
Please state your name.
Robert Cole.
Mr. Cole, this is the time for your initial appearance. You are here today on felony charges of weapons misconduct and reckless display of a deadly weapon. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney, and it is ordered appointing the Pima County Public Defender's Office to represent you. We are going to discuss your conditions of release today, and I have reviewed the interim complaint describing the circumstances surrounding your arrest. I have also reviewed information provided by pretrial services, which lets me know whether you have any prior felony convictions, and if so, what those look like. It also tells me whether you were able to provide information or references regarding your ties to the community, and it contains their assessments and recommendations. The state is recommending that you be held on a bond of $20,000. Would the state like to be heard further?
Your Honor, this person came home incredibly intoxicated, allegedly. Picked a pipe, loaded it, brandished it, threatening the victims. Also used a a metal pipe. It would appear he's also a prohibited possessor. Police recovered all the aforementioned weapons pursuant to a search warrant. We've got a history of FTA, likely prison time based on this, and an ongoing risk to the victims. $20,000.
Great. And defense.
Your Honor, understanding the gravity of the charges brought against Mr. Cole, the fact of the matter is he's a business owner. He's a contributing member of our community here in Tucson. Certainly these are allegations the state has brought. They've proven nothing, and he's presumed innocent unless they can prove them. Certainly, I can understand, the danger that the state has alleged here. The fact of the matter is nobody here was injured. These, as the state describes it, these are threats as part of some sort of verbal argument. I don't know that $20,000 is appropriate under the circumstances. I would ask Your Honor to instead, if you're going to impose a bond, that you impose something to the tune of $5,000, something that Mr. Cole might be in a financial position to actually afford, post, and secure his release, putting up some form of money or collateral to secure that release to pretrial services. In the alternative, Your Honor, I do think that pretrial services would be sufficient to ensure his compliance with the court's orders to not possess any weapons, to not have any contact with the alleged victims, giving him the opportunity to return to his business so that it does not suffer, and continue to be a contributing member of our community, working and presenting a defense with the assistance of counsel. So for these reasons, Your Honor, I'm asking for pretrial release. Given the circumstances, if the court is going to impose a bond, I would ask that you do so at no greater than $5,000.
Thank you. I am going to order a bond of $10,000 cash or secured, pretrial services if that bond is posted. Monitoring or treatment is directed by pretrial services. No alcohol or illegal drugs, no firearms or weapons. Sir, if you do own any firearms or possess any firearms, you must surrender them to local law enforcement. No contact with the alleged victims, and do not return to the incident location until further order of the court. And I will schedule a preliminary hearing for you. That is on August 1st at 1:30 in the afternoon. If you were to be released and then fail to appear for any future court dates, a warrant can issue for your arrest. Do you understand?
Yes.
Thank you. That's all for today.
Thank you, Judge.
Cox.
Good morning. Please state your name.
Cox.
Ms. Cox, this is the time for your initial appearance on a number of different matters. There are new felony charges of possession of a narcotic drug, as well as felony charges from April of this year of possession of a narcotic drug and possession of drug paraphernalia. And then there are some misdemeanor cases as well. There's a charge of shoplifting and then failing to appear on that charge from 2023 out of Pima County Justice Court, and then charges from November of 2024 of shoplifting, criminal trespass, and then failing to appear at your court date for those charges. And then there's also Tucson City Court cases, some of which were in failure to appear status and some of which were in warrant status. The charges include possession of drug paraphernalia, shoplifting, 2 counts of criminal trespass, and possession of drug paraphernalia. And those date back to as far as 2022. You have the right to remain silent on all of these matters. Anything you say can and will be used against you. You have the right to be represented by an attorney in the felony cases. In the misdemeanor cases, you always have the right to hire an attorney of your choice, and in certain circumstances, an attorney may be appointed on your behalf. We are going to discuss your conditions of release in all of these matters. And I note that the state is recommending pretrial services release on the felony charges and that you may be eligible for the STEPS pre-indictment diversion program. That is a program that connects you with substance abuse treatment providers, and if you successfully complete the requirements of the diversion program, it is possible that the state will not move forward with the felony drug charges. Are you interested in that program, ma'am?
Yes.
So I will set your felony cases for a hearing to determine your eligibility, and if you wish to join the program, you'll have the opportunity to speak with pretrial services, service providers, and an attorney further about the program. That will be on July 29th at 9 a.m. It's important to attend that hearing because I believe that's the only chance you get. If you miss that hearing, you won't be given another opportunity to be screened and potentially join that program. And then I am likely going to order bond amounts because of the lengthy history of failing to appear. In that circumstance, would counsel, would the defendant like a small bond on the felony matters as well?
That certainly makes sense, Your Honor, for the back time. My concern is that somebody who is screened and accepted into the SMART STEPS or SMART program doesn't begin until they're released. So the concern is that if she's held on a bond, she doesn't begin the STEPS programming in either felony matter. But, you know, given the court's inclination on the misdemeanor counts, yes, I would ask for, say, $100 bonds on either of the felony matters, just to make sure that she's awarded the back time that she would get for those cases.
Thank you. And I do understand the concern there, but it's just too lengthy a history of failing to appear. So, all right. So on each of the felony charges, I will order a bond of $100, cash or secured. Pretrial services, if that bond is posted, monitoring or treatment as directed by pretrial services, no alcohol or illegal drugs, no firearms or weapons. On the older case, the one from April, your next court date other than the STEPS hearing is going to be the same day as the STEPS hearing, but later that afternoon. So it's July 29th at 1:30 for an arraignment. And then on the newer felony drug charges, your next court hearing other than the STEPS hearing is going to be scheduled for August 1st for a preliminary hearing. Well, if you are accepted into the steps hearing, there's a good chance that hearing will not go forward. However, if you fail to appear and it does go forward, a warrant can issue for your arrest.
Real quick, Your Honor, the bonds on those felony matters, are those concurrent?
I think I cannot order them concurrent because of one of them is still at Pima County Justice Court for preliminary hearing, whereas the other one is already set for an arraignment at Superior Court.
That's correct, Your Honor.
But I am willing to reduce them to $50 each. Oh, did you already? Oh, thank you. Okay. And then the conditions of release are the same. And then on the shoplifting charge, I will also order a bond of $50, cash or secured. No alcohol or illegal drugs, no contact with the alleged victim, do not return to the incident location. I will appoint Janet Altschuler to represent you in the Pima County Justice Court misdemeanor cases. And you'll be seen tomorrow at 1 p.m. for those. That will be for an arraignment with Judge Pesquiera at Pima County Justice Court. And then it'll be the same thing on the newer shoplifting charge. $50 cash or secured. The next court date will be tomorrow at 1 p.m. with Judge Pesquiera at Pima County Justice Court. No contact with the alleged victim, do not return to the incident location, and no alcohol or illegal drugs. If you remain in custody, then the jail will make you available for that hearing tomorrow at 1 p.m. And if you are released before then, it's your responsibility to appear. If you fail to appear, the court may issue a warrant for your arrest. And then finally, we'll turn to the Tucson City Court matters. And then for those cases, I'm going to order a bond of $150 cash or secured, no alcohol or illegal drugs, no contact with the alleged victims of the shoplifting or trespass. Do not return to those incident locations, and I will appoint the City of Tucson Public Defender to represent you. In those matters, it's a little bit more complicated. If you remain in custody, then your next court date will be August 1st at 1:45 for a video review, and the jail would make you available. However, if you are released, the city court is going to vacate that court hearing, and instead you'll have court on August 25th at 9 a.m. for a pretrial conference. And again, if you fail to appear for any future court hearings, a warrant can be issued for your arrest. Do you understand, ma'am?
Yes, ma'am.
All right, thank you. That's all for today. Thank you. Felony and Justice Court. Oh, I do. Sorry. Oh, and some more.
Richard. See.
Good morning. Please state your name.
Say for me.
Oh, yeah.
For the judge.
Oh.
Still. What does that mean? Yeah, tell the judge your name.
Oh. Touch it?
No. Tell her your name.
Oh, I'm sorry. I got hearing aid and it's running low on batteries.
Gotcha.
Name Richard Grskoviak, birthday 8/4/45.
Mr. Griskowiak, this is the time for your initial appearance. You are here this morning on charges of criminal damage to property. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney, and it is ordered appointing the public defender's office to represent you. We are going to talk about your conditions of release, and I have reviewed the interim complaint. I have reviewed information provided by pretrial services about you, and I have reviewed the state's recommendation that you be released to pretrial services. So I am going to order that you are released to pretrial services. You'll be required to submit to monitoring or treatment as directed by pretrial services. You may not possess or consume alcohol or illegal drugs, and you may not possess any firearms or weapons while you're on pretrial release. No contact with the alleged victim of the criminal damage. Your next court date will be August 11th at 1:30 for a preliminary hearing. It's possible that court date will change, but you want to make sure you know what your court dates are, because if you fail to appear, a warrant can issue for your arrest. Do you understand, sir?
Yes.
All right. That's all for today. Thank you.
Thank you.
You should call that number when you get out.
Okay. Thank you.
Yeah.
One second.
Good morning. Please state your name.
Justin Joyner.
Mr. Joyner, this is the time for your initial appearance. You are here this morning on new felony charges of shoplifting and trespassing in the second degree. You also have a number of charges out of Tucson City Court, including several counts that were in warrant status or failure to appear status. That includes 2 different counts of criminal trespass, 1 count of shoplifting, 2 counts of possession of drug paraphernalia, and then you also have new misdemeanor charges of unlawful possession of a prescription drug and 2 counts of possession of drug paraphernalia. You have the right to remain silent on all of these matters. Anything you say can and will be used against you. You are presumed to be innocent, and I will enter pleas of not guilty on your new Tucson City Court charges. We are going to discuss your conditions of release today. I have reviewed the interim complaint, which describes the circumstances surrounding your arrests, and I have reviewed information provided about you by pretrial services. That lets me know whether you have any prior felony convictions, and if so, what those look like. It also lets me know whether you were able to provide information to pretrial services about your connections to the community or any references. As well as their assessments and recommendations. Would the state like to be heard any further?
State submits on the $5,000 rec.
Thank you, and defense.
Yes, Your Honor. One thing I noted in looking at this complaint is there's an allegation of, this being charged under shoplifting under the subsection I of 1805, which requires a number of prior burglary, shoplifting, robbery, organized retail theft, or theft convictions within the past 5 years. The only thing available on the pretrial services record is 1 prior shoplifting conviction. I don't have information that there are other prior convictions that would count under this statute, specifically that subsection that he's been arrested under. So lacking that, that information, I would argue then that there's a probable cause issue for the shoplifting as it relates to that subsection. And in terms of the bond, Your Honor, I would ask that the court is going to impose a nominal bond and hold Mr. Joyner. I would ask that you do so in an amount that he would actually potentially have the ability to afford. And so because of his financial circumstances and that being something the court is obligated to take into consideration, I'm going to ask that you release him to pretrial services or in the alternative, hold him on at most $1,000 bond with the addition of dismissing the shoplifting count based on lack of probable cause for the information that has been provided to defense counsel for this case.
Your Honor, I see a organized retail theft in 2020. Date of incident 5/14/2020, sentence date 6/8/2021. And bear with me while I look up the county, the state, the overall state's website. One moment. A moment. And what I see, Your Honor, is several in the Tucson Tucson Municipal Court. Checking this one, hold on. Shoplifting, May of this year. Got quite a few, Your Honor.
Thank you. I don't think I need any more information on the probable cause. All right. All right, so I do find probable cause. I don't believe that they have to be felony priors. I believe they can be misdemeanor priors, and misdemeanor shoplifting priors would not generally show up in the criminal history for pretrial services. So I don't think the fact that they're not showing up there tells us anything. And I am going to order on the felony charges that you're held on a bond of $250 cash or secured, pretrial services if that bond is posted, no alcohol or illegal drugs, no firearms or weapons, no contact with the alleged victim, and do not return to the incident location. And your next court date is scheduled for a preliminary hearing on August 1st at 1:30. If you were to be released before then and then failed to appear for future court hearings, a warrant could issue for your arrest. And then on the Tucson City Court matters, that I'm going to order a bond of $250 cash or secured covering all of those charges. The additional conditions of your release are no alcohol or illegal drugs, no contact with the alleged victims of the shoplifting or criminal trespass charges. Do not return to those incident locations. I will appoint the City of Tucson Public Defender to represent you. And if you remain in custody, your next court hearing will be a video review on August 1st at 1:45. If you have been released before then, they will vacate that court date, and instead, your next court date for Tucson City Court will be August 25th at 2 p.m. If you fail to appear, a warrant can issue for your arrest. The hearings can go forward without you, including trial. And if you are convicted and then fail to appear for sentencing for 90 days, you can lose your right to a direct appeal. I will enter pleas of not guilty on your new misdemeanor charges. You are presumed to be innocent. Do you understand, sir?
Yes.
All right, thank you. That's all for today.
They're gonna hold me.
That's loading.
I don't even have Okay, thank you. Good morning. Please state your name.
Pete Moody.
Was that Keith Moody?
Yes, ma'am.
Thank you. This is the time for your initial appearance. You are here this morning on charges of possession of a narcotic drug, possession of a dangerous drug, and possession of drug paraphernalia. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney. I am appointing the Pima County Public Defender's Office to represent you. And we are going to discuss your conditions of release this morning. I have reviewed the interim complaint, information from pretrial services, and the state's recommendation that you be released to pretrial services. There's also an indication that you may be eligible for the STEPS pre-indictment diversion program. That is a program that connects you with a substance abuse treatment provider, and if you complete the requirements of the diversion program, it is possible that the state will not go forward with these felony charges against you. Are you interested in that program?
Yes, ma'am, Your Honor.
All right, so I will set your case for a hearing to determine if you are eligible and wish to join that program. That hearing is on July 29th at 9 a.m. It's very important to appear for that hearing because I believe you only get one chance to be assessed and to join the diversion program. If you didn't appear for that hearing, you wouldn't get another chance. I am going to order that you're released to pretrial services. You'll be required to submit to monitoring or treatment as directed by pretrial services, no alcohol or illegal drugs, no firearms or weapons. And then I do need to set a preliminary hearing for you. Usually those need to occur within 20 days. However, to give time for you to be assessed and potentially join the diversion program, would you be willing to waive that out to 45 days?
Yes, ma'am.
All right, so I will order setting a preliminary hearing for you on September 5th at 1:30 in the afternoon. If you are accepted into the diversion program, it's possible that hearing will not go forward, but it's important to be certain about that because if you fail to appear, a warrant can issue for your arrest. Do you understand, sir?
Yes, ma'am.
All right, thank you. That's all for today.
Yeah. I'll see you. You too. Los solis.
Good morning. Please state your name.
Stefan Solis.
Yes.
Mr. Solis, this is the time for your initial appearance. You are here this morning on charges of burglary in the second degree, aggravated domestic violence, and there's 2 counts of that, and then possession of drug paraphernalia. You have the right to remain silent on all of these charges. Anything you say can and will be used against you. You have the right to be represented by an attorney, and it is ordered appointing the Pima County Public Defender's Office to represent you. We are going to discuss your conditions of release this morning. I have reviewed the interim complaints describing the circumstances surrounding the charges. I have also reviewed information from pretrial services that lets me know whether you have any prior felony convictions, and if so, what those look like. I have also reviewed, it would also let me know if you have relevant misdemeanor convictions. I have also reviewed whether you provided any information or references regarding your ties to the community and the assessments and recommendations completed by pretrial services, as well as the state's recommendation that you be held on a bond of $75,000 concurrent to both cases. And I finally note that there is a probation hold for which you are currently detained without bond. So regardless of what I ordered in these matters, you would not be released until that was cleared up. Would the state like to be heard any further?
State submits on its recommendations.
Thank you, and defense.
Yes, Your Honor. I'm going to ask that you impose a $7,500 nominal bond for both of these cases concurrent with one another. The reason being is not only is there a probation hold through Superior Court, there's a DOC hold. Yeah, there's a DOC hold on Mr. Solis, so he's going to be held without bond on that. You know, in the 2 new matters, again, we're asking for a nominal bond. I don't know how long the DOC hold is for or any details for that, and I can't apprise the court of that information. But I would ask that you enter bond in these 2 cases concurrent, such that Mr. Solis might have the opportunity to actually post that bond, either on his own self or with the support of family members or friends, to give him that opportunity to actually secure his release. I don't know that $75,000 is a realistic number for that by any means, and that is, of course, something that the court needs to take into consideration is his own ability to pay. And so we don't know at this juncture what the DOC hold looks like, other than that it exists. He's going to be held. He doesn't have the possibility of release. I'm asking that you give him nominal bonds in the 2 new matters so that if he does cross that bridge, he will be in a position to possibly afford posting those bonds. Thank you.
Thank you. I'm going to order in the felony matters a concurrent bond of $25,000 cash or secured. If you are released, you'll be released to pretrial services, monitoring or treatment as directed by pretrial services, no alcohol or illegal drugs, no firearms or weapons. absolutely no contact of any kind with the alleged victim starting immediately, and do not return to the incident location. Your next court date will be August 1st at 1:30 for a preliminary hearing. It's possible that court date will change. It's very important that you appear for any court dates because if you fail to appear, a warrant can issue for your arrest. Do you understand, sir?
Yes, ma'am.
All right, thank you. That's all for today.
Guilty number.
Please state your name.
Desmond Williams. Good morning, Your Honor.
Morning. This is the time for your initial appearance. You are here this morning on a couple of different matters. You have new felony charges of burglary in the 3rd degree and possession of drug paraphernalia. Sorry. Yes. And then you also have a charge of assault out of Tucson City Court. You have the right to remain silent on all of these matters. Anything you say can and will be used against you. You have the right to be represented by an attorney in the new felony matter, and I am appointing the Pima County Public Defender's Office to represent you. We are going to discuss your conditions of release this morning, and I have reviewed the interim complaint as well as the officer's narrative from the city court case. I have also viewed information from pretrial services that lets me know whether you have any prior felony convictions. It also lets me know whether you were able to provide information or references regarding your ties to the community. And it contains their assessments and recommendations. Finally, I have reviewed the state's recommendation, which is that you be held on a bond of $2,500 on the felony matter. Would the state like to be heard further?
No, Your Honor.
And defense.
Yes, Your Honor. I'd ask that you release Ms. Williams to the supervision of pretrial services. She has no prior felony history. She's got a place that she's currently staying with her own grandmother. She's also got the home available to her via her boyfriend, who's indicated he'd be willing to take her, as well as allow her to receive mail at his home. It seems either of these locations are on the reservation. She's got, family and support through her own community. She has those ties to the community and services available through to her through the tribe. And so this is not somebody with, an extensive, it looks like, failures to appear. This is somebody who, is facing their first felony level charges, Your Honor, of which she's presumed to be innocent. And so for these reasons, Your Honor, I'd ask that you allow her to return to her home, to her community, to her boyfriend, and allow her to participate in her defense, from home with the support of the public defender's office, rather than remain here in jail. These are not violent allegations that the state has brought. There's not an extensive history that the state is alleging. This is one incident. It looks like both the assault case and the felony matters are dated the same day and are one number apart in complaints. I don't have any of the allegations related to the assault in front of me. I wasn't provided with that complaint. But I think the circumstances indicate that Ms. Williams is not somebody that the court needs to be concerned with failures to appear or a threat to the community. So for these reasons, I'm asking that you release her to pretrial services. That supervision is more than sufficient to ensure that she stays above board. Thank you.
Thank you. Ma'am, I am going to give you a chance on pretrial services.
Thank you.
The orders are that you must submit to monitoring or treatment as directed by pretrial services, no alcohol or illegal drugs, no firearms or weapons, no contact with the alleged victim, and do not return to the incident location. Your preliminary hearing is scheduled for August 11th at 1:30 in the afternoon at Pima County Justice Court. If you were to fail to appear, a warrant could issue for your arrest. And then in Tucson City Court, I will release you on your promise to appear. No alcohol or illegal drugs, no contact with the victim, do not return to the incident location. And for Tucson City Court, your next court date will be August 25th at 9:30 with Judge Maldonado for a pretrial conference. You are presumed to be innocent, and I will enter a plea of not guilty on your behalf for the Tucson City Court charge. And if you fail to appear, a warrant can issue for your arrest. The hearings can go forward without you, including trial. And if you are convicted and then fail to appear for sentencing for 90 days, you can lose your right to a direct appeal. Do you understand?
Yes, ma'am.
Thank you. That's all for today.
Thank you, Judge.
I didn't give it to you. I must
Abby?
Yep.
Thanks.
You're welcome. Good morning. Please state your name.
First name Nabi, Nabi. Last name Yavari, Yawari.
Thank you, Mr. Yawari. This is the time for your initial appearance. You are here this morning on charges of aggravated assault. There are 3 counts. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney, and I am appointing the Pima County Public Defender's Office to represent you.
Thank you.
We are going to discuss your conditions of release today. I have reviewed the interim complaint, which describes the circumstances surrounding the charges. I have also reviewed information provided by pretrial services that lets me know whether you have any prior felony history. It also lets me know whether you were able to provide information or references regarding your ties to the community. And it also contains their assessments and recommendations. The state is recommending that you be held on a bond of $15,000 and if released to pretrial services. Would the state like to be heard further?
No, Your Honor. No, Your Honor.
Thank you. And defense.
Yes, Your Honor. If I could have just a moment. Yes, Your Honor. I'm asking that you release Mr. Yorawi to the supervision of pretrial services. I understand the allegations that the state has brought. It's certainly clear that there's more to this story than what is listed in the complaint. What is clear, however, is that Mr. Yorawi was the valid owner of this vehicle that had been repossessed. He owns the car lot. He owned the vehicle on it and has the title to it. The individuals that the state has elected to list as victims in this case had come and were essentially what the state might otherwise charge as burglary of a structure. They had broken into this vehicle. They were attempting to take items out of the vehicle that Mr. Yorawi owns and had made from upon information and belief, threats to him or had attempted to strike him with their own vehicle. He was, and he looks forward to clearing his name and defending himself. I believe that the state has charged this case poorly. They've charged the wrong people involved. Mr. Urawi attempted to call 911. Officers arrived hours later and arrested him rather than the people who had come and were messing with the vehicle that he himself owned. So it's very clear just from the complaint at first blush, he's got valid justification defenses as it relates to defense of premises, defense of property, and self-defense, as well as defensive display. So his conduct, I think, just based in what the state is alleging, is justified. He's got no prior criminal history, no felonies, no failures to appear, nothing that would indicate that he is someone that the court needs to be concerned with not showing up to his court dates, not participating in this case, or presenting a threat to either the community or the listed victims, Your Honor. This is somebody who I think was caught in a very difficult situation, and based on what the state is alleging, has very valid defenses. And so I think pretrial supervision is going to be more than sufficient to ensure that he continues to participate in this case. I think he's going to be very motivated to provide what evidence he can to clear his name, because it's, as I said, Your Honor, I think there's far more to this case than what is listed in the complaint.
Thank you. I am going to order a bond of $2,500, cash or secured, pretrial services if that bond is posted, monitoring or treatment as directed by pretrial services, no alcohol or illegal drugs, no firearms or weapons, surrender any firearms that are in your possession. Your next court date is scheduled for August 1st at 1:30, and if you were to fail to appear for court after being released, a warrant could issue for your arrest. Do you understand, sir?
Yes.
Thank you. That's all for today.
Thank you, Judge.
Thanks, everyone. Have a good day.
Good day, Your Honor.